Raising the Bar podcast, brought to you by the Association of Gray's Inn Students.
Hello and welcome to this, the fourth episode of the Meet the Barrister series for the Raising the Bar podcast with me, Alana Hughes. In the Meet the Barrister series, I speak to a different guest barrister in each episode and discuss their path to the bar and their practice, as well as any other interesting topic of discussion that pops up. The aim of this series is to demonstrate that the bar is not a one-size-fits-all sort of profession, as it is sometimes wrongly assumed to be. Barristers come from a wide variety of backgrounds and specialise in many different areas of law. There is something for everyone. Lockdown measures that have been in place to combat the COVID-19 pandemic have begun to be eased in the UK. But here at Gray's Inn, we are still very much social distancing to keep everyone safe, and that means that this episode is being recorded remotely, and there may therefore be a slight reduction in audio quality, which we hope you won't mind. One of the benefits of our move to remote recording means that we're now able to have guests on from outside of London, and today is our first episode with a barrister on the Northern Circuit. My guest today was called to the bar in 2016 and is almost 3 years into a tenancy at Dean's Court Chambers in Manchester. Prudence Beaumont is a specialist family law barrister and enjoys a wide and varied family practice encompassing public, private and financial remedy work. Prior to coming to the bar, Prue was an English literature teacher in a secondary school, having obtained a PGCE and a Master's in Education before embarking on the GDL to convert to law. Prue has kindly agreed to come on the podcast to speak with me about her path to the bar. Prue, hi, and welcome to the Raising the Bar podcast.
Hi, thank you very much for having me.
So Prue, can you tell me why it was that you decided to become a barrister?
Law was something that I had been interested in for some time, and I think it was probably something I had thought about prior to making my university choices, although I read English at university and not law. And I had been involved in lots of debating at university and run an outreach programme with children as part of that. And I identified through doing that just the importance of advocacy and the necessity of providing people with the appropriate education so that they can voice their own opinions and views on matters and the value that that holds. I think that that links very closely to what I do now as a family barrister, because it is ultimately about giving a voice to individuals in society who are often voiceless. Certainly that's true of children, and it is almost certainly true of the most and the more deprived members of our society. So that was my main focus. It was about the advocacy primarily. I was also interested in the academic rigour of the law and what life at the bar is like, and I was drawn to the independent nature of it as a profession.
I know before you studied the GDL and BPTC, you completed the Teach First programme. Could you tell me a little bit about what that programme is?
Yeah, so Teach First is a graduate programme. It's 2 years long, and its mission statement, so to speak, is to ensure that all children have fair access to good education, regardless of their socioeconomic background. What it does then is it places so-called exceptional graduates, their phrasing, not mine, into some of the most deprived schools in the country. Prior to being placed in those schools, there's an intensive 6-week training programme called Summer Institute, where you are taught the basics, and I think it's fair to say they very much are the basics of teaching. Then you start teaching in that September on an 80% timetable, and unlike the PGCE, where you would be phasing up, doing little bits of lessons and progressing to teaching a full lesson, right from the get-go, you are in the classroom on your own as the primary teacher of that lesson. And over that first year, you gain your PGCE qualification, essentially, or the equivalent of, and your qualified teaching status with that, by undertaking assignments alongside your teaching. So for the most part, you do your assignments and your essays in the school holidays. And in the second year, you carry on as a newly qualified teacher, and as part of that, you undertake the training that any other teacher would be undertaking if they were commencing their first year in the teaching profession. It's my understanding that about 50% of those who do it stay and 50% go, and that's about equivalent to the retention rates with teaching, generally speaking, anyway. So it's given that these graduates are being placed in challenging contexts, and that's quite a good retention rate. And I chose at the end of my 2 years to leave and pursue a career at the bar.
In terms of the experience that you gained by completing that programme, it gave you a lot of obviously non-legal experience then that you could bring to the table in scholarship interviews and pupillage interviews. Do you notice any particular transferable skills between what you learnt in your training as to become a teacher and being a barrister?
Absolutely. The first point is that I was asked about it endlessly in interviews, in scholarship interviews and in pupillage interviews. People were really interested to hear about it. It certainly has transferable skills because the very act of teaching is a form of advocacy. It allows you to deal and be more confident in dealing with interventions, and part, of course, of the job of a barrister in court particularly is that judges intervene, witnesses are difficult, and it allows you to have a confidence, I think, in managing those interventions because you are used to dealing with it in a classroom, and a classroom is significantly more chaotic an environment than the courtroom, which is much more civilised for the most part than your average classroom. So yes, that was certainly one of the transferable skills, was the advocacy. The other, of course, is stress management. I think the process of thinking on your feet and maintaining a calm exterior when inside you might feel a bit panicked or a bit concerned is a bit of an art form that all barristers have to master. And it certainly is something which Teach First assists you with, because that's very much the process you undertake whilst you're in the classroom when somebody asks you a question you don't know the answer to, or does something that is totally inappropriate, like throwing a glue stick at another child's head, and how you react in that moment and manage situations. So I think it's very useful in terms of keeping your cool under stress. And as with any other professional job, it's about managing your priorities and time management skills, which of course are as useful at the bar as they are in almost any other job. I also think that for me, it was valuable in giving me an insight into actually what people's real lives are like that are very different from my own, because the reality is that I've had a very privileged upbringing and had all the opportunities, and whilst I may well have academically understood that people were less fortunate than me, I think being confronted with it in real life with a child who hasn't had any breakfast and has got hunger pangs, or doesn't have any clean clothes to wear, or whatever that might be, is a very important life lesson. And that's especially valuable if you are working with those individuals as adults in your professional life, which of course I am within the area of family.
So what then, if any, influence did your work in education have on your choice of family law as a specialist practice area?
I actually really wanted to do crime initially. Perhaps didn't have as much influence as one would have thought, but I did make applications for family sets too. I feel very much as if family chose me a bit more than I chose it, but it is an obvious fit given my teaching background and actually my personality and skill set. Generally, that family I think I was better suited to. My experience of education certainly assists, because as part of family law I certainly deal with a lot of school reports and understanding about terminology that's used in school and various acronyms. It has assisted me undoubtedly having a working knowledge of those matters in terms of having a confidence with dealing with them within family proceedings, but also having an understanding of those children and managing their expectations, particularly if I'm representing an older child with whom I may be taking direct instructions. I think my ability to liaise with them is much better because I have had to do that on a regular basis within teaching previously.
And now that you've been a tenant for almost 3 years, are you finding that you're starting to find a specific area of family law that you hope to further specialise in, or are you intending to maintain a varied practice with elements of both public and private work?
So my practice is, as you rightly identified, still divided into public and private and some finance work too. My preference is quite strongly for public law. I feel that is where the most important work is done. That's not to diminish the valuable work that those in the other spheres do, of course. But I find that work most interesting and most challenging, and I think it raises the most interesting moral and legal points. So for me, the focus going forward is likely to be more public law than the other areas.
And what sort of specifically would you be able to pinpoint as your favourite type of case to be instructed on?
I like medical evidence, so cases, non-accidental injury cases where there's complex medical evidence. I think that they are fascinating. I'm interested really in all the aspects of public law. There isn't a particular type of case I have any strong affinity with. For me, the part of the interest in it is that it is a fascinating expose of what human life is like, and it's the same as looking at it really closely under a microscope or under some sort of lens, because you have in family, I think, unlike crime, access, and that is somewhat of a privilege, to the most detailed and intimate aspects of people's lives. You read their medical records, you read the school reports of their children, you read all the police disclosure, and so you have quite a full picture even before you meet your client, if you're representing a parent, for example, about what they might be like based on the papers. I think that's one of the elements of it that I think is fascinating, and that probably relates to my love of literature, because it is, when you read it on paper before you meet them, almost like a shocking novel in many ways, and the complexities and the characters and the interplay between all of those aspects. So I think, I don't know if that really answers the question, but...
No, definitely. You've mentioned meeting clients in person, and I suppose in today's current climate that's not really been possible for the past few months. How have you found the shift to virtual hearings, where getting to meet a client face to face is a privilege that we haven't been able to have?
I think it's really challenging. I think it highlights the importance of face-to-face contact. The cases that I've been doing in recent weeks have been less contested as a result of it not being considered fair for lots of things to proceed in the way in which they ordinarily would, and it not being fair for them to proceed remotely. Video conferencing certainly provides some advantages to that, but dealing with hearings on the telephone, and obviously a lot of the family hearings are going forward via the telephone as well as via video hearings, I think is very difficult, and because it's not until it's taken away from you that you realise how much you gauge from your client when you first meet them, from their body language, and not so much what they do say, but often what they don't say and how they don't say it. And I think particularly for cases such as interim removal hearings, where the court is being invited to remove a child from the care of a parent, they are some of the most stressful proceedings for parents. They're often brought on an emergency basis, and parents often feel that they haven't had a huge amount of notice, and dealing with that without having met your client properly, I think, is very challenging. So it certainly highlighted to me the importance of real human contact in conducting proceedings.
And I suppose in a way that's something that is specific to family law, particularly where that human contact is really needed, because people are ultimately having one of the worst days of their lives when they attend court.
Absolutely, and I think that part of what makes good family barristers is an understanding of exactly that people are having a dreadful time, and they need some reassurance from you to a certain extent. That being said, there are some hearings that most certainly can be dealt with remotely, and I imagine will continue to be dealt with remotely after this lockdown eases up, because they are dealt with more efficiently and more quickly. But certainly contested hearings, hearings where you're meeting clients for the first time, there's no substitute for the face-to-face real life meeting, I don't think.
I remember on one of my first mini pupilages in a family set, the barrister said to me that in the public family cases, there is never a winner or a loser, and the aim is just to make a terrible situation just a little bit better for your client. Do you agree with that idea, that that's ultimately what you get up in the morning to do, to try and make awful situations just a little bit better for people?
No, sometimes there is a winner, I think, and there certainly is a feeling after protracted proceedings where a child returns home and you're representing a parent who's been desperately wishing for that child to return home for many months, often, beyond the 26 weeks or within that time frame, that they have won because they have got the outcome that they wanted. Although saying that, the fact that they've had to go through that process in itself means that they have lost to a certain extent as well. So there is a balancing act. There are many more hearings which don't conclude with any kind of feeling of triumph, and I think that feeling that you've made it slightly better is probably true. And there are certainly, for me, it is more difficult when you have hearings where you feel that parents have been not failed by the family justice system, but failed by the state and by the community on a more wholesale level. So they haven't had an adequate education, they haven't had any support with issues in relating to housing, they're living in difficult circumstances. There are issues with drugs and alcohol, perhaps. They've had very, very difficult, challenging childhoods, and they are a product of those circumstances, and they've not had the opportunity to access anything which could ameliorate that. I think those hearings are very difficult, and I think that's when you feel like you're maybe making a dreadful situation just slightly better by virtue of the representation you're able to offer them. I find that aspect of it certainly quite frustrating, though, because sometimes you are limited by what you can do by virtue of the circumstances that individual finds themselves in.
And when you do find yourself limited, and when you do find yourself working with a client who has been burdened with, deep-rooted systemic failures, and nothing has, gone in their favour in their entire lives, how do you process that sort of in your own mind in order to move on and sort of accept that there's not really a large amount that you can do for that client?
I think it's very difficult, and I think that the bar is still adjusting to accepting the idea that is difficult. There is, I think, still a predominant theme that people say, things which I think are actually quite unuseful, like, well, you're too busy at the bar anyway, so you just don't think about it because you move on to the next case. And while some of that is true, and you are very busy, there are certain cases and certain individuals that do affect you or impact you in a way that others don't. And it's strange, because I think preparing for cases, because it is so busy, is much like cramming for an exam. So in the immediate days after a case, I could tell you the date of birth of the child with whom the proceedings were concerning. But 3 weeks later, I might not be able to tell you the name of the case because it's crammed for that purpose. And unless it has had some specific feature or some specific impact, I may not remember the details of it off the top of my head. I think that you deal with it by talking about it with your colleagues at the bar. I think part of the joy of being a barrister is the collegiate sense of the bar, and I think people talk about that in a kind of throwaway way, but I think actually it's really valuable, and they're the people who understand best what those difficult cases are like. And I think there's a lot of discussions that go on amongst barristers, and certainly I have those conversations with friends in chambers and outside in other chambers who practice in family law about, the kind of railing against those systemic failures and the concerns about that. But ultimately you have to preserve yourself to a certain extent and do the very best you can, and leave work where work belongs, because otherwise I think if you don't, it's probably quite damaging for yourself.
You've just mentioned the collegiate sense of the bar, and I suppose in a way that collegiate atmosphere is best exemplified by the inn and the structure of the four inns. How was it? I know you're on the Northern Circuit and you might not get down to London very often, but how was it that you decided to choose Gray's?
I made my decision based on kind of the profiles of the inns, really. I did a bit of research about them prior to joining Gray's, and I looked at kind of who had been there previously and links with the circuits. I think Gray's historically has had quite, I think this may not be so true anymore, but I think previously had quite a strong link with the Northern Circuit, and Rose Helbram was of course a member of Gray's Inn, and she was a leader of the Northern Circuit some time ago now, obviously. But so I looked at those kind of factors. I was quite keen to be in a smaller inn where I felt that I might be better nurtured and supported. And certainly that has been my experience of Gray's, that it has always been very supportive as an environment, albeit that the reality is I'm not sure now, I'm in practice and I'm a tenant, how much day-to-day regular contact I have with the inn, because as you identify, I'm on the Northern Circuit, and so I'm not popping down on a regular basis.
But in a way, I mentioned in my introduction, one of the benefits of this move, because of COVID-19, to more virtual connectivity and a more virtual community is perhaps going to be something going forward that is embraced by the inn. And I know that it's definitely something that's being looked at to mean that all circuits can get involved with qualifying sessions, can get involved with continuing professional development. So do you feel that going forward, the move to virtual might help with sort of the isolation that you might feel in a way from London because you're on the Northern Circuit?
I think it's really difficult. I never felt when I was doing the bar course that I was in any way... I did the bar course in Manchester, so I didn't do that in London either. So I travelled down I know there were some limited qualifying sessions on circuit. For the most part, I travelled down to London. I didn't for a moment feel when I was in London that I was an outsider or a comer in from the Northern Circuit. I felt as welcomed at the inn as I think anybody else from any other circuit. So I was very heartened by that, because I didn't feel there was any difference. I have stayed at the inn in the accommodation when I've been in London on a few occasions, and that's been a nice way to connect with the inn. I think the reality is we are very busy, and it would definitely help if there was some more online things which those of us who are not based in London could connect with, and more activities taking place and dinners and various other things outside of London, because the reality is that by the time you finished in court and got down to London, although the train's fairly fast, it all becomes a bit complicated, certainly if it's something that's midweek. But yes, I definitely welcome an increased involvement with the inn on circuit.
I know that you were awarded GDL and BPTC scholarships by Gray's Inn. How vital were these for you in facilitating your career at the bar, not just in terms of obviously the financial assistance that it gives towards the enormous fees, but also confidence in the sense that panels of esteemed barristers believed that you were the right fit for the profession?
It was absolutely vital. I would not have pursued a career at the bar without them. I already had a professional job that I was having to give up for very poor odds at having a go at another career. So I had to be fairly sure that I had stood a reasonable chance. I mentor quite a few students who are thinking about pursuing a career at the bar, and I tell all of them, particularly those that are non-law graduates, that they must apply for scholarships. I don't think the take-up and the knowledge around particularly the GDL scholarship is particularly well known. I think that's less so for the BPTC scholarships now. I don't think they are quite well known amongst most of those that are applying for the bar course. Absolutely vital in terms of confidence. I think it stands you in great stead. I think one of the other advantages aside from the financial and the confidence building, is that the structure of the interviews are very similar to pupillage interviews. So even just attending, and this is what I always say to anyone I'm mentoring, even just attending and having a go at the interview, even if nothing comes of it, is a brilliant experience, because, as you say, the panels are really esteemed members of the bar who often will have sat on their interview panels within their own chambers. So I think it's a really useful opportunity in that regard as well. But no, it was vital, and the fees are, they're extortionate. And they certainly were when I was doing it. I know that the Inns have been working quite hard in terms of looking at the structure of the bar course in recent years, but I did the bar course just prior to those changes coming in. No, I would not be at the bar without those scholarships. I didn't have any other financial help from any family. I would not have been in a position to do it without them. There's no doubt about that.
Finally, Prue, just before we finish, I just want to ask, what is it that you enjoy most about being a barrister?
I feel like there should be some learned answer for this. I think I probably enjoy cross-examining the most about being a barrister and calling evidence. I think that's what's been difficult about being in lockdown, is that it's not the same over a remote link, and I'm certainly doing less of it. So calling evidence is certainly, and being in court is certainly the aspects that I enjoy most about it. I also really love the people at the bar. I think it's actually a real privilege to be surrounded by so many bright and interesting individuals, and I find the clients that I have the privilege of representing, be that a local authority, be that a parent or a child, endlessly interesting and challenging. So it's been brilliant. I regularly tell people that I think it's the best job in the world, and I stand by that.
What are your hopes for the future in terms of how you hope your practice grows? And I know, obviously, with your background in education that you've discussed with me today, are there any other projects or work outside of your role as a barrister that you might want to get involved with in the future?
I'm a school governor, so I do that alongside being at the bar, and I do a fair bit of mentoring and various other, the bar mock trial and things like that. So I've tried to use where I can those skills and that knowledge I have from education and blend the two where I can. And I hope I'll be able to maintain those links with education, particularly because I am strongly of the view that the bar has a chronic problem in terms of recruiting individuals from less affluent backgrounds, and particularly those who are from ethnic minorities. So that is something which certainly I would want to be involved in supporting that change. So I think that's my kind of hope for the future in terms of doing other bits and bobs. But yeah, I don't know what my hopes are professionally, really, rather than still very early days. So I think that's one of the strangest things about this job, is that most of us have been jumping through a lot of hoops and exams for many, many years before we get here. And then you take tenancy, and then that's just your job until you might think at some point perhaps of applying for a judicial appointment, or that those are so far in the future. So at the moment, just the desire is to keep doing interesting work and to carry on enjoying it.
Prue, thank you so much for your time. I know that you're super busy with virtual courts, and I'm really, really grateful that you came on to have a chat with me, and it's been really lovely to hear about your journey to the bar. Thank you.
Thank you.
Thanks for listening to the Raising the Bar podcast. Please subscribe, rate and review. And for more information, check us out on Twitter @RaisingTheBarGI.